we will start. Welcome to Introduction to Immigration Law. My name is Maria Daniel, and I'm an immigration lawyer based in Northfield, Michigan. Today, I will talk about, give a brief introduction to immigration law and recent changes that have happened since the new administration came in the last year. The difference between LPR, which is a lawful permanent resident, and a USC, which is a US citizen, how to become a lawful permanent resident, and how to become a US citizen. So like I said, my name is Maria Eugenia Daniel. Only the people that know me from Argentina use my middle name, but I love it, so I keep putting it there. I've been an attorney for over a decade. I studied initially in Argentina, and then I moved to the US and continue my studies here. I've been representing immigrants across the different immigration entities in the United States, such as Immigration Court, the Board of Immigration Appeals, USCIS, consulates around the world, and I do removal defense, business immigration, and family petitions as well. I know that immigration is usually a hot topic, especially around elections, because it's something that it can be, it's really something that people talk a lot about. And in recent years, there has been a lot of people trying to cross the southern border. I know there has been a lot of news about that. Most notably, what has happened since the new president came in is that they have switched the priorities for detention and removal. So when before everybody who was basically anyone who was an immigrant was a priority for removal, ICE, which is the immigration police, had great freedom to just arrest anyone and put them in removal proceedings. Now they are acting under strict orders of only focus on people who are either a danger to the community, a danger to national security, or are a threat to the border. So basically anyone who has been in the country for a long time, even if they're undocumented and they do not have any criminal record, or they don't have anything in their history, or they're not doing anything that will alert authorities, they will most likely just leave them alone and not proceed to arrest them and try to deport them or remove them. That has caused also it's an ongoing shift in immigration courts and removal proceedings. A lot of cases are being dismissed when they find that the person they're trying to remove or is in removal proceedings does not fit within those priorities. They're dismissing the cases. The problem that is causing right now, at least from with those people, is that once they are not in removal proceedings anymore, they lose their employment authorization. So they go from having it while they were in removal proceedings to not having it anymore. And that, of course, causes a lot of issues, especially in the state of Michigan. People that are undocumented or do not have employment authorization, they cannot apply for a driver's license. So it creates a lot of problems. But hopefully, I mean, we're trying to, a lot of organizations that work with immigrants are trying to fix that and see how we can go around it. There's just nothing yet because it's very new. It's developing as we speak. Another big issue that has been going on is that USCIS has what it's called as a backlog. That has been caused because of COVID and because of lack of resources for USCIS. USCIS is the administrative agency that handles most immigrant petitions in the US. Petitions that used to take 2 to 6 months are taking years now. And so what the government is trying to do is they have set new priorities for different applications, and they have set new guidelines and procedures for the people that are working there to speed things up. We still haven't seen any progress, but hopefully it will come up. Another thing that this government has been doing a lot, this administration, is designating TPS. TPS, it's called temporary protected status. And there are several countries that have temporary protected status. Usually what that means is that even though the government determines that the person can be removed because there is some situation in their country, such as a war, or it's not safe for them to return, they will grant them this, it's called TPS, and they will allow them to stay in the country and have work authorization. In the last few months, they have designated Ukraine, Sudan, Cameroon as TPS. At the end of 2021, they also designated Venezuela as another country for TPS because of all the things that are happening over there. Another thing that has been in the news a lot is the Remain in Mexico, or MPP program. MPP stands for Migrant Protection Protocols. And this is a program that initiated a few years ago that allowed Border Patrol, when someone came to the southern border asking for asylum, they would place them in removal proceedings, issuing a notice to appear in court, but instead of being them allowed to either wait inside the country or being detained, which is what usually would happen, they are returned to Mexico, and then they tell them a date and time that they need to show up to a port of entry to go appear in court, where they will have their day in court to be heard by the judge. And if the judge grants them asylum, then they can stay. If the judge doesn't, then they have to go back. That has created a lot of problems, especially during the worst of COVID, because a lot of people were stuck in Mexico, the courts were closing, the borders were closed. And so it created living conditions over there that were not good. It was stopped by the Biden administration as soon as Biden came in office. Unfortunately, a court in Texas ruled back in August that they couldn't do that, and they had to continue using this program for immigrants. So in December of last year, it went back into motion, and it continued. And now they continue to place people in migrant protection in a BP program. And currently, actually today, there were oral arguments in front of the Supreme Court to address this issue, and they were going to decide whether they can continue doing this or not. We'll see what happens. Some interesting numbers. As of November of 2021, there were 46.2 million immigrants in the United States. That includes documented and undocumented people, out of over 332 million population overall. Out of those immigrants, the majority are Mexicans by far. The second countries that come after are China and India, then the Philippines, Vietnam, Cuba, Dominican Republic, Guatemala, and Korea. The states with the most immigrant populations, unsurprisingly, are the states in the South. So Arizona, California, Texas, Florida, and surprisingly, Wisconsin and Virginia. In Michigan, we have a population of almost, or at least in 2019 was the last information I could find. That was a census. It was about 700,000. I'm sorry about that. 700,000 immigrants in the United States, in Michigan, I'm sorry, and about 14% of the children in Michigan are in immigrant families, meaning their parents are immigrants. They are most of those children are born in the United States. I thought it was interesting. So lawful permanent residents and US citizens. Usually these are the goals that most immigrants, when they come to the United States, are looking for, because this is what gives them a sense of permanency in the country. A lawful permanent resident is known as an immigrant visa, which means that a person that obtains it is allowed to live and work permanently in the United States. There are no restrictions of where that person can live or where that person can work. Except for they can't hold public office, but other than that, they can work anywhere. They may petition for spouses and single children under 21 years old. That means that they can ask for lawful permanent resident for those people. It may be conditional for 2 years. That happens when the petition is when the person gets the lawful permanent resident through a spouse, and they have been married for less than 2 years. USCIS, instead of giving them permanent lawful residency, they give them conditional residency. So at the 2-year mark, well, actually 90 days before the 2-year mark, they need to apply to remove those conditions. and show that the reasons why they were granted that residency are still valid, meaning they're still married, the marriage is still in good faith. It can happen because life happens that people get divorced, so they're not married anymore, and they have provided for that in their, it's called a waiver, where the person can file by themselves and show that even though they enter the marriage in good faith, it ended for whatever reason, and then they can still get the conditions removed. Once they get those conditions removed, they would get the permanent resident card. The card is usually, it's granted for 10 years. When the card expires, it doesn't mean that the visa or the LPR status expires. It's just the card that expires. The person continues to be a lawful permanent resident as long as they meet the other conditions to be there. Mainly, the conditions are maintaining physical presence in the United States, and not doing anything that would revoke that card or that status, which is no voting or holding public office, and not committing certain crimes that can eventually put the person in removal proceedings in front of a judge, and then they can take the residency away. Maintaining physical presence means that the person needs to be in the United States at least 180 days in 1 year. So that's 6 months of the year they need to be in the United States. They also need to file taxes in the United States. That is very important to establish residency, because if their tax person is somewhere else or their tax home is somewhere else, it's a very clear indication that the person is not a resident of the United States, and that's what the visa or this immigrant visa is intended for. If the person who has a lawful permanent residence is a lawful permanent resident, thinks that they're going to leave the country, and for whatever reason they're going to be outside of the country for more than 6 months, outside of the United States for more than 6 months, they need to apply for a re-entry permit, and they need to do it before they leave the country, so when they come back they have it. If they're outside the country longer than 6 months, then it creates a presumption that they have abandoned the residency, and they have to prove that they haven't. This can be a very complex process that has to be done abroad in the consulates, or by the person in re-entering, and then there would be sometimes they're immediately put in removal proceedings to go to the judge and show why they did not abandon their residency. But if the person has been outside of the country for, say, 2-3 years, they have a job somewhere else, they are filing taxes somewhere else, they have a family, then it's a pretty clear evidence that the person is not a lawful permanent resident of the United States. They may have other visas available, but the lawful permanent resident, the green card, is not it. They need to find another way. A U.S. citizen, on contrast, once a person gets the U.S. citizenship, they basically have the same rights as a U.S. citizen that was born in the country or that acquired the citizenship through their parents. That person, that citizenship is transferable to children born outside of the United States. That is very important, because the lawful permanent resident status is not transferable. And for them to come back to the United States with kids or new spouses, they have to apply for their own statuses. Where the children, it's a very complex part of the law, because it keeps changing, and it depends exactly on what day you were born and what year you were born, and if your parents were married, they were not married, if it's just one parent or two parents that are U.S. citizen. Also for who you worked, because sometimes if you work for the U.S. government where you're abroad, as in the Army or any other public service, the rules change. I could have like a whole another talk about that topic alone. So I'm not going to go into detail, but the main point is that U.S. citizenship is transferable to the children, where lawful permanent residence is not. U.S. citizens can also petition for more people. They can petition for their spouses, for children under 21 years old, for married children, for children over 21 years old, for parents, and for brothers and sisters, which is a lot more people than the lawful permanent resident can't. The U.S. citizenship cannot be revoked, and it is permanent unless there was an error when it was initially granted. It is very rare that something like that happens. The error has to be very clear, and the person has to be honestly a pretty bad citizen for that, or to get the attention of immigration officers, and then them trying to revoke that citizenship that was granted after many, many years of immigration process usually. There are basically 4 main ways of getting lawful permanent resident status or the green card. It can be done via family petitions, via employment-based petitions, humanitarian visas, or the diversity visa program, which is known as the green card lottery. Family-based petitions are so it's when the petitioner is either a U.S. citizen or a lawful permanent resident, and they want to either give status to a person that is already in the United States, or bring someone from abroad. Usually, if it's a bride, or if they're engaged and they want, and the future spouse has children, they want to bring them into the United States, they can apply. There are 2 ways that this can be done. If the person is inside the United States, the person that is going to get this status is in the United States, and they enter with a visa. They can do the process that is known as adjustment of status. That means that they can apply for the green card without having to leave the United States. If the petitioner is a U.S. citizen, that person could have been in the country for many, many years without lawful status, and they can still adjust status. So say, for example, someone came in the 90s with a tourist visa, their tourist status expires 6 months later, they decided to stay for whatever reason, 10 years later, they meet someone, they fall in love, they get married, that person is a U.S. citizen, they can adjust status without leaving the United States. If the person enter without a visa, then they would have to do consular processing and ask for a waiver or forgiveness of the time that the person spent in the United States with unlawful presence. So the application initiates in the United States via USCIS, and then there's a second step where it goes through NVC, the National Visa Center, and it gets directed to the consular of the country of origin of the person to continue the process in the consulate. That is usually something that scares a lot of people, because if you leave and you don't know all the details of your immigration process, you can get surprised once you're there and find out that you may be inadmissible for other reasons that you didn't know about. And then you can get stuck in the country outside of the US for 3 or 10 years, sometimes permanently, if you are subject to the permanent bar. So that's very scary. So I highly recommend that someone contacts a lawyer before they leave the country, if they're not 100% sure that everything is on track. For lawful permanent residents, it's a little different, because even though they can adjust, the beneficiaries of those visas can adjust status in the United States, the beneficiary has to have maintained status during the time that the visa was pending. So for example, a person comes in as a student, if the student status is say 3 years, they need to apply for adjustment of status before that status of student expires to be able to adjust in here. If not, they would have to go and do it outside of the country. Another fun visa that fits into this category is the fiance visa. I think a lot of people have heard about that. I know there's that TLC show or whatever, 90-Day Fiance or something like that. That is a fun little one. It's a visa that people can get if they have a fiance outside of the United States and they want to get married. They do have the condition that they have to have met at least once in the last year before they apply for the visa. That can be waived, though, if there are religious reasons why they cannot meet. There are some countries out there that they don't allow people to meet before they actually tie the knot. So they don't, and they can come in. The condition is that once they come in the country, they legally married within 90 days, and then they adjust status to lawful permanent resident or the green card once they get married. They don't have to file for the adjustment of status within the 90 days, but they do have to get married within the 90 days. If they adjust status immediately, they will get that conditional residency that I was talking about earlier. If they don't, and they wait, say, more than 2 years, and they stay married for more than 2 years, then they will get a permanent resident. The permanent residency, not the conditional permanent residency. The other issue with that fiance visa, and it's something that a lot of people don't know, is that once you come in with that fiance visa, you can only adjust status based on the fiance that brought you to the country. So if you come in, you decide you don't like him anymore, you fall in love with a neighbor, you can't adjust status with the neighbor. You have to marry the person that brought you in. That can create a lot of complications too later on. And usually for those people, it's better to just leave and then come back another way. Another big issue about adjusting status in the US is that coming to the US, once someone gets to the border, it is very important that they have a clear idea of what their visa allows them and their intent in entering the country. There is a presumption at the border that everybody that is coming in, no matter for what, no matter what your visa says, there's a presumption that you are going to want to stay in the country and that you're going to stay. And it's the person asking for admission responsibility to prove that you're not going to stay. So if you have a tourist visa, you cannot say, oh, I'm here to marry my fiance. That's a huge no-no. You're here to be a tourist. Go see the Statue of Liberty, go see the Golden Gate Bridge, and then go back home. If you change your mind, which you can, it's not a problem, but you have to at least be in the country for 90 days before you can change your mind without having a presumption of fraud. If you change your mind before that and you file for an application for change of status or adjustment of status before the 90 days, then you will have to prove that you did not defraud the government when you enter the country and you said that you were going to come to X and you decided to change it to Z. So intent, very important to keep in mind when crossing the US border. Employment-based petitions, these are, there are two types of employment-based petitions. They're the non-immigrant petitions and the immigrant petitions. The immigrant petitions are, non-immigrant petitions are those that are granted for a temporary time and eventually the person leaves the country. I'm not going to talk about those today. I'm going to talk about immigrant-based petitions because those are the ones that lead you to the green card. The other ones don't. In some circumstances, again, you can change your intent, apply for something different, and become a lawful permanent resident or stay in the country, but those, again, another topic. So these visas, employment-based, are, they have different categories, and the government, the way they review them is they grant about 140,000 applications a year, and they are, they review them by order of preference. There's preference from 1st to 5th. I'm only going to talk about the first 3 because the other 2 are not relevant to this conversation. And they first grant the first preference, then when they're done reviewing those and they reach the cap, then they move to second preference and they move to third preference. There's a cap, there's a numerical cap on total of visas. It's usually 28.6% of that they can grant of those 140,000, 20.6% to each category, and no more than 7% of those visas can go to one country. There is this fun little thing called the visa bulletin where the government announces each month of the year where these categories are and what applications they're reviewing. Because when we file a petition, we get a receipt notice that has what it's called priority date. That date tells us when that application is going to be reviewed. So when we go to the visa bulletin, we check the priority date that have, say, for first preference, and it says, if it says C, it's current, it means I can apply for adjustment of status immediately. If it says November 2019, then I have, and my application says, I don't know, December 2019, I have probably to wait another month or 2 before I can file for adjustment of status. That becomes very important for certain countries that have a very high immigration rate, especially in employment visas like India and China and the Philippines. They have their backlogs are years and years. That also happens with priorities for family members that are not immediate family members. So for brothers and sisters, I mentioned earlier, then US citizens can petition brothers and sisters, but those applications right now, they're reviewing applications from the 90s. So it takes years and years, I mean decades, for someone to bring a brother or sister. So it's really not an option, but it's there. So hopefully they'll do something to speed those things up, but I mean, we'll see. So the first preference is for people with extraordinary ability, outstanding professors and researchers, and multinational managers and executives. Extraordinary ability is usually shown, it's usually people that are in the arts, education, athletes that have recognition at a national and international level in their field. And they have to meet very specific requirements of what they have to show in order to get this visa. As a funny example, what they say in the USCIS website is, if a person won an Oscar, winning an Oscar would be a good example of your extraordinary ability. So it's very limited. Not a lot of people can do that. Outstanding professors and researchers, obviously they don't need to win an Oscar to come teach in the United States, but they also have to be recognized nationally and international in their field. And multinational managers and executives, it requires that the company that they're working for is connected to the US, either by it's an affiliate, a subsidiary, or somehow the company that they're working for abroad is connected to the company here in the United States. The good thing about the first preference is that they can apply, the people that are applying for this can apply by themselves. That means that they don't need a sponsor, they don't need an employer, they don't need an employment offer, nothing. They can just apply for themselves. If they show all of these criteria, they will get a visa as long as it's current. The second preference, they need to get, for the second and the third precedent, a labor certification. The labor certification is a document that the employer needs to request from the Department of Labor that proves to the US government that employing a foreign national will not affect work conditions for US workers, and that they will, that there's no one else available, willing, or capable of performing that job. It's a really high threshold to show, and usually the way it shows is like we have to put people through, the companies have to do a recruiting process that it's very extensive, and you know, collecting resumes, reviewing the resumes, calling people for interviews. They can't just say, oh, there's nothing, nobody wants to work. I put a sign of help wanted, nobody showed up, let's get somebody else. So once they get, but once we get that labor certification, then the person can apply, or the employer has to apply for the employee. They have to have a job offer in place. It can't be just something up in the air. It has to be a very strict job offer to come. And for the second preference, it's reserved for professionals that have an advanced degree, that is something more than just a bachelor degree, or persons with exceptional ability. For the first, inside this preference too, there is sometimes they can apply for themselves if they can show that their employment is in the national interest. So they can apply for what's known as a national interest waiver, and if it gets approved, they don't need to get a sponsor that will actually bring them. The third preference are for skilled workers, professional who required a college degree, or unskilled workers. This usually requires that the person really knows what they're doing and they have some experience working in the field a few years before they can apply for this third preference and get their green card. Humanitarian-based petitions are Usually there, for these petitions, there needs to be an underlying petition that has been approved before they can apply for the green card. This usually covers asylees and refugees, special immigrant juveniles, victims of domestic violence, and victims of certain crimes. The difference between an asylee and refugee is an asylee is someone that is already in the United States. They enter and they ask for asylum because they're afraid to go back to their country. A refugee has to ask for refugee status outside of the United States, and then they come in with that status. For asylees to become lawful permanent residents, they need to be granted the status. And then after a year of having the status of asylee or refugee, they can apply for the lawful permanent resident. And their derivative spouses or children, that means people, spouses or children that were in the application with them and they were granted derivative status as a derivative asylee status, they can also apply for lawful permanent resident. Unfortunately, right now, there's a huge backlog with asylum applications. And backlog is my favorite word, I guess, today. Word of the day. Some asylum applications take 10 years or so to get processed. And then it's really sad because if people are already here, they formed lives, they have families, and then they get denied, they have to go. There are two ways of asking for asylum. It can be either affirmative or defensive. Affirmative is when a person comes in and they apply directly with USCIS. Defensive is when they come in with a visa. Defensive is when they are placed in removal proceedings, and as a defense, they say, don't deport me, I'm afraid to go back to my country. The biggest thing about asylum is that people have to apply within 1 year of having entered the country. If they applied after a year, it's not asylum anymore, it's withholding of removal, unless they meet one of the exceptions that allows them to apply for asylum. But those are very hard to prove too. So it would be withholding of removal. And if they get withholding of removal or protection under the Convention Against Torture, they cannot later on adjust to lawful permanent resident. They can be here for a very long time. But if the conditions change in their country and all of a sudden ICE decides that they're not afraid to go back, then they can return them. And they are also basically confined to the United States because they can't go, they can leave. Once they leave, they lose that status. Special immigrant juveniles this is actually the fifth, it's within the fifth category of the categories I was discussing earlier. And this is a status reserved for children that enter the United States that are under 21 years old. And they are under the protection of the state court. And they cannot be reunited with one or two or both of their parents, either because of abandonment, neglect, or abuse. And so those children, they have to go through custody proceedings in state courts. They get put either under the custody of the state or the custody of one parent or a guardian. And if the court makes a finding that they cannot go back to their country because of abuse, neglect, or abandonment, and they cannot be safely reunited with one of their parents, or one or two of their parents, then they can apply for a green card. Victims of domestic violence, it's pretty self-explanatory. It covers not only spouses, but also parents and children of US citizens and lawful permanent residents. The condition is that they live together, and if they can prove that they suffer abuse or extreme cruelty in the hands of a lawful permanent resident or a US citizen, they can apply for adjustment of status or the green card without having to have the abuser petition them or sponsor them, which makes a lot of sense if you think about it. Victims of certain crimes for U visas and trafficking or T visas, they can apply after 3 years of holding U or T visa status. Those statuses are usually granted for 4 years, and they can apply between year 3 and 4, and they must do it between year 3 and 4. These are visas, U visas are visas that are granted for people that have been victims of crimes in the United States. There's a long list of, I think it's 17 or 18 crimes. It covers from the most serious as murder, kidnapping, Any kind of sexual abuse, domestic violence is covered under that too. So any person that has been a victim of those crimes or a secondary victim, meaning if someone is murdered, obviously that person that died cannot apply for a visa, but the relatives that were secondary victims can apply for this visa as long as they collaborate with the police and the prosecution of the crime. That is very important because in order to do this whole process of the U visas, the first step is to get a certification from either the police or the courts that says this person did help in the investigation or prosecution of the crime, and therefore they can apply for this U visa. T visa for trafficking is for people that were brought into the country under false pretenses, basically, and they were put into either work or abused because by a person in the United States. If they, it's usually easier if there's an investigation. We don't handle a lot of those visas. There's some people out there that do a great job with them, and I honestly leave it to them and refer those cases. But they're good cases. They're it's those all of these cases are cases that are good in helping people and giving them a chance when they think that otherwise they don't have it, and mostly at least the last three, so VAWA, U, and T, are to encourage the people that are victims of this crime to come up and talk to the police and make sure that the people that needs to be prosecuted are actually prosecuted, not just out there creating more damage. The diversity visa program, it's what it's called as the Green Card Lottery, and there are certain countries that participate every year. The goal of this program is to increase immigration from countries that the United States consider have low immigration rates. And so people have to sign up in, I think it's October that they sign up, and sometime around early May, now they give the results. If the person gets selected by the visa lottery, that doesn't mean that a green card will automatically show up in the mail. That would be amazing, but it's not the case. They still need to apply for the green card for immigrant status, and they usually do it at the consulate where they're from. And they need to prove that they are admissible to the United States, meaning they're not, generally is, if you don't have any health issues, you're not going to be a public charge, meaning you're going to be able to support yourself and not going to depend on the government for support. You are not, you have not committed certain crimes, then they will give you the green card or the paperwork. Is a stamp on your passport. You come into the border. Once you cross, you have to pay what is called the immigrant fee, and then you do get the green card on the mail. It's a great thing. A lot of people sign up every year. Only a few get it, but it's a good thing, in my opinion. It's literally a lottery, right? If you win, you go. So how do you become a US citizen if you're not born here? You have to be at least 18 years old at the time you apply. The person has to have been a lawful permanent resident for at least 5 years or 3 years. 3 years is reserved for people that are married to US citizens and they continue to be married at the 3-year mark. Then they can apply for citizenship. At the 3 years, they don't have to wait 5 years. Everybody else has to wait 5 years. They have to show that they have continuous residence and physical presence in the United States. That goes back to what I was talking about earlier. They need to be in the country for the past 5 years, at least 6 months out of the year, and show that their residence is here. So they have to show that they pay their taxes, or their address is here, their physical address and mailing address. They're employed in the United States. They have to be able to read, write, and speak basic English. They have to demonstrate that they have good moral character. That is usually shown by, again, filing taxes, properly filing taxes, not just, putting a bunch of dependents that are not your dependents, or not declaring income. All of that is not good moral character. So you have to make sure that your taxes are being properly filed. and by not having any criminal arrests that are serious. A few traffic tickets are not going to be an issue. Now, if you're drinking and driving, that will be a big problem. Demonstrate knowledge and understanding of U.S. history and government, which is known as the civics test. That is, they changed it, but a couple of years ago, but now they change it back. And it's 100 questions that people need to learn. And they ask, well, you need to answer 6 out of 10 questions correctly. If you answer the first 6 correctly, you only get asked 6 questions, but it's usually 10. Demonstrate loyalty to the principles of the U.S. Constitution and be willing to take the oath of alliance is the last 2 requirements to become a U.S. citizen. There's certain waivers to the English knowledge and the civics test. If you're a certain age and you have been in the country for a certain amount of years, you can ask for a waiver, or if you have a medical issue that prevents you from learning the language or reading and writing. It has to be a very serious medical injury, and it requires a medical certification from a doctor. So it can't just be, oh, I have bad memory, or I can't just sit down and study. It's not, that's not gonna fly. So for, I lost my train of thought. I apologize. Give me 1 second. Oh, okay. So for the process for applying for citizenship, it's done through a form that is filed at USCIS. It's for form N400. That form gets processed. If you're applying at the 3-year mark, you need to file evidence that you continue to be married to the person that you applied for initially. If you do not, if you are filed at the 5-year mark, you do not to prove that you continue to be married. But it's also good to include taxes just to show good moral character. It speeds up the application, but no, there's really not a lot of evidence that is required at this stage. Once the application gets processed, the person is usually called for fingerprints. That means that they have to go to a local field office, leave their fingerprints, take a picture. And then they get called for an interview where the officer will review the whole application, do the exam, and test for English, speaking, written, and reading, speaking, and writing English. Usually the speaking, reading, and writing, the speaking and understanding English is tested because the interview itself is conducted in English. So if you can review the application easily with the officer, then clearly you understand English. And the writing and the reading is usually the same questions that are in the civic test. They just pick one, you don't know which one, and they ask you to read it, and then they ask you to write the answer, and they tell you what the answer is. So you don't have to guess. And so that's why it's so important, so good to just learn that civics test and read it. And not only, I know there are great CDs, I'm sure they have it here in the library, and I know we provide links for that too in the office, but it's good to just sit down and read it because it will be part of the exam. If the person passes all of these exams, then they will be called for the swearing ceremony, and that happens again at the same office at USCIS. There's one in Detroit, and there's also one in Grand Rapids. And the person gets sworn in, and once they get sworn in, they're officially a U.S. citizen. They get a certification of naturalization, and with that, they can go get a passport. It's very important that from the time that interview happens to the time the person is sworn in, they do not travel and outside of the country. And once the person becomes a U.S. citizen, they are required to enter the country with the U.S. passport from then on. You're not required to renounce to your previous citizenship. You don't have to. You only have to pledge loyalty to the U.S. But once you become a U.S. citizen, you have to come in with that U.S. passport. You can't act like, I'm from Argentina, I couldn't use my Argentinian passport to come in. And you have to continue to pay taxes in the United States because the IRS always wants those dollars. I think that concludes my presentation. I don't know if anyone, I will open up for questions. If anyone, and my information is there with typo, I'm sorry, it's 248, not just 24. So if anyone has any questions, I know I unloaded a lot of information, so.
I came because I have some, not family, I would consider them family, but they're not family.
Okay, I have people like that too.
Yes, so I call them my sons, but they're not. And they're in Honduras area.
Okay,
And one of them in particular keeps telling me he wants to come here.
Okay.
So I thought I'll come and find out some information. And I tell him, because he's always, you know, they're in the poor area of Honduras, so they're wanting, he sometimes talks about coming legally.
okay,
I've been trying to discourage that highly and say you've got to do it legally. So his first step obviously would be passport and then visa. His dream is to come here and be in the military.
Okay.
Is that even a possibility?
yes,
I was like, I'm trying to find facts. I don't want him to come here illegally. I think it's way too dangerous, and you know, you want to do it the right way. But obviously, he's young, feels a little bit despair, and wants to just do what he wants to do. So I'm trying to say, do this, give him some information.
yes. So obviously we do not encourage people to come illegally to the
Right.
country, especially it's very, very dangerous. The
Yeah.
Mexican border right now is one of the most dangerous places that
That's right.
anyone can be at.
Mhm.
There is, however, the option for the person to show up to the border and ask for if they can come in. They need a reason to come in. A lot of people that come from what is known as the Northern Triangle, Honduras, Guatemala, and Salvador, they're claiming asylum, they're escaping gangs, they're escaping
Right.
crime, they're escaping cartels, all of that, and they can be paroled in. Right now, with what I just mentioned about the Mexican protocols program, the migrant protocol program, or MPP, they could be returned back to Mexico and just wait there for asylum. And if they don't have a viable claim for asylum, then they're not going to be allowed to come in. If he is a minor, if he's under 21 years old, though, that might be different. So that the age can make a difference. Regarding coming in, the best way obviously is to get a passport, get a visa. He can get a tourist visa, he can get a student visa if he wants to come and explore high school, college, even an English program if he wants to come in and learn
That might
English.
be the best one to do the student visa.
Yes.
And then see if he can get it transferred later on to get into the military. That
Yes.
might be a
So I don't know exactly what the requirements are to get in the military, but there are a lot of options available for people that are in the military to apply for status, and they can even apply for status for their family members after they met certain conditions in the military. And it depends also on the branch. I think the Air Force, they can't, the Army and the Navy, they do. But again, I'm not 100% fluent on requirements to enter the military.
So is it difficult to get a student visa?
To get that would be an F1 visa, and the first step would be to be admitted into an institution in the United States that is authorized to apply for him to come in. So it's if he can get admitted into a program, then it's not. He just needs to be very careful about intent again,
Right.
because a visa, an F1 visa, is a non-immigrant visa, which
Right.
means ultimately he has to say he wants to go back. He's just coming in to be with family, learn English, and then he wants to go back. And also be very, very careful about social media. Now when they ask for to fill out the applications abroad in the consulates, they ask for those social media handles, so Facebook, Instagram, and they go through them. And if they see anything that gives them the indication that they're going to be coming and staying, then they will get, it's really bad if they're already here. So if they're already not here, I'm sorry, if they're at the border and the border patrol determines that the person is not, their intent is different to what their visa is, they will be put in expedited removal proceedings. And they don't even see a judge. They just remove them, send them back home with a 5-year ban that they cannot come in the country. And after that, after you get that 5-year ban, it's really, really hard to get a visa to come back because you already have this huge red flag on your record that you tried to come in the wrong way. So it's very important for people to be very careful about what they have on their phones, on their person when they cross the border.
So I would have to find like an institution like college or a high school that would.
Yes, and there are there's a website. If you send me, my email is not there, but my email is maria@veramarlegalgroup.com. Send me an email and I will send you the website where all the approved institutions are that can help you with that.
Thank you.
And this is an FYI, somebody has tested, you have more questions, please speak with.
Oh, okay.
So it was Marie.
Maria,
And just at the
Veramar Legal Group. Yes.com.
And you saw that.
Yes, so there is, I read that USCIS takes your native country passport if you pass the citizenship interview. Is that not the case if you can maintain citizenship in another country? So you can have passports as long as, okay, so you can have passports from 2 different countries as long as you use US passport to re-enter the US. So USCIS does not take your passport if you're applying for citizenship. USCIS usually will take your passport if you're, and it's not USCIS that takes it, it's actually ICE. If you're placed in removal proceedings or if you enter the border without admission, without inspection, and you're detained by ICE, then they usually retain your passport as well. And you don't get it back until you finish your removal proceedings. USCIS will not retain your passport. They will ask for your IDs. Usually when you go to the citizenship interview, when you have to bring is your green card. So your passport is not there at all. So I hope that answers your question. So yes, you can definitely have passport from 2 different countries. And usually what happens is, again, I'm gonna put myself as an example. I would enter the United States with the American passport. And then if I go to Argentina, I would enter Argentina with the Argentinian passport. So I don't have to be a tourist there and pay for reciprocity fees as an American when I'm Argentinian. Or if I needed a visa for another country it all depends. As long as you enter the US with your passport from the US, you can do whatever you want outside of the US. Any other questions? No? Okay.
What,
I know there's some people that wish to do so, people will be born in this country and in another country, subject to US citizenship.
Yes, so you can renounce your US citizenship if you want to, especially if you are a US citizen and you were born here but you live somewhere else, like you said, and you want to be a citizen of another country. You can renounce to it, definitely. It's easy if you want to quit it. It's easy. It's just that if you want to come back, that's when it becomes because it's not. They don't like it. They want your tax money. So if you renounce it and then you want to come back, that is the difficult part because you regaining that citizenship is not easy. What I mentioned is that once you are a US citizen, it's very hard for them to take it away, for the government to come and be, oh, you're not a citizen anymore, we're taking it back. That's why we recommend that anyone that is a lawful permanent resident, I'm hearing myself on echo. Anyone that is a lawful permanent resident and can apply for US citizenship and they have no what we call red flags, that nothing is, so they can apply, that they do apply for citizenship because it's permanent status, it's forever, unless there was something wrong before with it. But it's better.
we had she came to visit us. She lived in the US for 8 years and gone back to her home country, but then had come back to visit us. And she got stopped at the border because she could have claimed social security, and they were not going to let her in because they didn't want her going. Well, she'd been a green card holder previously.
Okay, so that sounds maybe, the question was about a person that lived in the United States for 8 years and she left back to her home country and then she came in as a visitor, so she didn't have a green card anymore when she tried to come in?
No, well, she hadn't gotten rid of it, it just expired.
Okay, but she hadn't been in the US for a very long time, more than,
That's 5 years.
okay, yeah, so it's probably, so the green card was probably presumed abandoned if they didn't make her abandon it. And, they would probably, what they did is found that she was inadmissible because of a public charge. She was going to become a public charge to the government and just claim money if she came back. That sounds like previous administration maneuvers. Unfortunately, they were very, very strict at the border, and sometimes not it didn't make the most sense. So was she did she have an expedited removal and get the ban, or did she like? Oh, she was? Okay. Oh, wow. No, and that's, yeah. Well, I'm glad eventually they let her out. That's good. She probably knew what to do. Usually, if the people that come in like that, again, CBP, which is the Border Patrol, they can't just take the green card away. Only a judge can take it away. But they sometimes manipulate people to sign a form that it's an abandonment of the green card there. And if you sign it, then you're doing it willingly. So you abandon your residency right there. So usually, if you're not don't sign anything. Unless you really understand what it is. Try to call a lawyer, a US lawyer. And the other thing that people can do at the border, if they see that they're not going to get admitted and things are just so they go to secondary inspection, which is usually a room in the back, and they're detained for a long time and they don't get an answer, they can ask to withdraw the request to be admitted. And if they do that, then they can't deport them because they're withdrawing the request to be admitted and they leave. Obviously, there's a record that you did that, and so it would be hard for the second time around to come in. But if you have more information to show that you're really coming in for the reasons that you're saying you're coming in, then you should be okay, and you don't get the penalty of the 5-year ban or issue. But yeah, the border.
Bob, did you have a question?
Yes. If a green card holder person commits a crime, can they be deported? And if so, under what kinds of crimes? Also, do they have to be found guilty, or can they just be charged? So I know it's a multi-sided question, but I've always been curious about the risk of a green card holder being deported due to a crime. A few years ago, I was tutoring a man, a tattoo artist from Brazil, and he quit his job in the studio because they were dealing with drugs. And I could see very easily how he could have been deported, even though he was not actually dealing with drugs, but he was present when they were busted.
Okay, so did everybody hear that question? Okay. So that's a great question, Bob. And out of the top of my head right now, I can't tell you exactly what crimes for the person to lose the green card. They do have to be charged and they have to be convicted, and it usually has to be a felony or more, or it has to be more than one crime. The person would not be immediately deported, though. They would be placed in removal proceedings, and they would have the opportunity to go to the immigration judge and plead their case. And there are different benefits that the person can apply for before they get deported. But usually if a person commits a felony or more than one felony, and if it involves drugs, so the case you're mentioning, it could potentially lead to a green card being revoked. So a felony or crimes involving moral turpitude, but it has to be, you have to be charged, you have to be convicted. And it also depends on how the statute is framed and written, whether it can create that kind of issue. But yes, a green card can be revoked if a person commits a crime.
Thank you. Thank you for your presentation. I appreciate that.
Oh, no problem. Thank you. Thank you for being there. Do we have any more questions? No? Okay, well, my information is right there on the screen. So if you want to reach me, if you have any more questions, I'm happy to answer them. We're based in Northville, like I mentioned. We represent people all over the country and the world. Because thanks to Zoom right now, we can do everything virtual or in person, even though I prefer in person. Don't hesitate to call me. And if anyone from this talk calls me and they just mentioned they were in the stock, I will offer a nice discount on a initial consultation. We usually charge $150. I will offer them for $50 for anyone that was here today or watches it later on the YouTube. Thank you. Thank you so much. And it was a pleasure spending the evening with you. Do you want me to hang up now or?